The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Horn. Good afternoon and welcome to the North Carolina Court of Appeals. My name is Linda Dean and I am the Chief Judge of the North Carolina Court of Appeals. And joining me today are Judge Hunter Murphy, Judge Chris Brook, and we look forward to being your panel this afternoon. I want to say a special thank you on behalf of the three judges to our Clerk of Court, Dan Horn, and also to our IT Director, Fred Wood, for having established and trained us in terms of being able to make use of the WebEx process to be able to move forward with cases before the Court of Appeals. We'd also like to welcome attorney for the appellant, Dan Gibson, and the attorney for the appellee, Andrew Cornelius. Is everyone ready to proceed?
I am, Your Honor.
Yes, Your Honor.
The sole case that we have for oral argument this afternoon is Mason Mitchell doing business as Mason Mitchell Motorsports plaintiff versus Scott Boswell defendant. We'll hear from the appellant.
May it please the court. My name is Dan Gibson. I represent defendant appellant Scott Boswell. I would like to reserve 5 minutes of my time for rebuttal. The question in this case is whether a memorandum signed only by attorneys is enforceable as a mediated settlement agreement when one of the parties to that memorandum denies his attorney's authority to execute that memorandum, and the memorandum expressly contemplates a future settlement agreement with more details. It is not, and for that reason, this court should reverse the Superior Court's order enforcing it as a mediated settlement agreement. There are 3 reasons why it is not enforceable. First, the statute of frauds in Chapter 7A bars enforcement of a mediated settlement agreement that is not signed by the parties. Because the memorandum is not signed by the parties, it's unenforceable under the statute of frauds. Second, even if it were enforceable, Boswell's attorney had no authority to execute the memorandum on his behalf. Third, the memorandum is unenforceable as a matter of law because it is an agreement to agree, because it expressly contemplates a settlement agreement. For the purposes of today's argument, I'm going to focus on the first 2 points. But before I begin that analysis, it's important for the court to note the standard of review here. When a party moves to enforce a memorandum of settlement, the summary judgment standard applies. That means that plaintiff in this case has to show that there is no genuine issue of material fact, and they are entitled to judgment as a matter of law. A court does not do several things when ruling on a summary judgment motion. It doesn't make credibility determinations, which means if there's competing affidavits, it doesn't decide which affidavit is more or less credible. It doesn't decide contested issues of fact. It simply decides whether there are contested issues of fact, and it does not interpret ambiguous contract language. What the court does do on summary judgment is take the facts in the light most favorable to the non-movement. In this case, that's Scott Boswell, and all reasonable inferences from those facts. And that standard is important because there are genuine issues of material fact here, and plaintiff is not entitled to judgment as a matter of law.
And I assume you're going to share those with us. Is that correct?
That's correct, Your Honor.
Before you get started into the substance part of your first argument, Mr. Gibson, I wanted to ask, where in the record can we glean that this statute of frauds argument was made at the trial court level? I've gone over the record numerous times, and I just don't see any recognition by the trial court that this argument was made below, or any recognition that that was raised in the pleading. You know, typically, it's an affirmative defense that has to be pled. There is some case law that you can raise it in an affidavit in response to a regular summary judgment. There's nothing in your client's affidavit here. So why should we even be considering the statute of frauds issue before you kind of get into the substance of the good thing as that we should rule in your favor?
Well, first, Your Honor, it's always appropriate for the court to consider whether, as a matter of law, a contract is enforceable in this context. I think the affirmative defense context arises where you're defending a claim directly. Now, admittedly, we're sort of in an odd context because plaintiff's claim in this case is a breach of contract, fraud, unfair and deceptive trade practices claim. But that wasn't what was decided at this motion for summary judgment or to enforce memorandum of settlement hearing. What was decided was whether or not this memorandum of settlement was enforceable as a memorandum of settlement. I can attest to this court that that argument was raised because I'm the one who made those arguments. If Your Honor would like additional documents to demonstrate that, I can certainly provide that documentation. But I think it's a little different to your standard affirmative defense context where you have a complaint and then an answer. This was a summary judgment hearing on what is almost a collateral issue, which is whether or not this memorandum is enforceable as a mediated settlement agreement. And on that basis, and on the basis of Mr. Boswell's affidavit denying that he executed it and denying that his attorney had authority to execute it on his behalf, I think the facts there make it clear that the statute of frauds is one issue to consider among many. And what the statute of frauds in 7A says, and it's at 7A-38.1 subsection L, is that a mediated settlement agreement is unenforceable unless it is signed by the parties against whom enforcement is sought. Now, that is a significant departure from North Carolina's established statute of frauds, which goes back to 1677, and the UCC statute of frauds. The statute of frauds that's been on the books in North Carolina for several centuries now reads that an agreement must be signed by the party against whom enforcement is sought or a party lawfully authorized by him thereunto. So what the General Assembly did here is they cut that statute in half. And when the General Assembly enacts new law, we presume that the General Assembly had knowledge of prior and existing law. So this is like the General Assembly passing a statute that says a contract requires offer and acceptance. We all know a contract requires offer, acceptance, and consideration. We don't assume that the General Assembly just left out that third element. Instead, we look at the statute and we say the General Assembly intended to remove that third element. And that's what the General Assembly intended to do here. They intended to require the parties themselves to sign a mediated settlement agreement. And that's consistent with the rest of Chapter 7A, which requires the parties themselves to attend a mediated settlement conference. Requiring the party's signature prevents the sort of disputes that we have today. It encourages greater solemnity and seriousness in a mediated settlement conference, and it doesn't present a significant issue to reaching a mediated settlement agreement. Mediated settlement conferences aren't something that just comes up spontaneously. The rules of Superior Court require them in certain cases, and often the parties have at least a month's advance warning. So if we're going to require the parties themselves to sign a mediated settlement agreement, which it appears it was the General Assembly's intent here, there's ample time for the attorneys on both sides and the parties to ensure that the parties themselves can execute a mediated settlement agreement or take appropriate other actions to ensure that a enforceable mediated settlement agreement results from the mediation.
The parties in this circumstance, even though the statute provides that they must be present, were not. Isn't that correct?
That is correct, Your Honor.
And that was an accommodation they both made together.
I think that's correct, Your Honor.
And could there not be an accommodation made in a circumstance where you require that both parties themselves individually or on behalf of a corporation sign the actual settlement agreement?
I think there's a number of accommodations that you can make in a context where the parties are attending remotely, which is what they did here. They didn't completely miss the mediation. They both attended by telephone. One accommodation could be appointing a power of attorney to act on your behalf. Another accommodation could be saying, if you're not going to attend physically, we need you to go to an office supply store or your office or somewhere where you have access to a fax or scanning machine so that you can sign this agreement yourself. Because the statute of frauds and the mediated settlement conference rules say time and time again that the parties themselves have to sign this agreement. Those accommodations weren't made here, and they're simple accommodations to make.
Speaking of accommodations and people working, remotely through a mediation, and that was agreed to by the parties, what application does the Uniform Electronic Transactions Act, Article 40 of Chapter 66-311, that's have to the statute of limitations? It was originally adopted in 1990, allows for electronic signatures to serve, I'm summarizing here, but to serve as the equivalent of a regular signature.
I think that's
overcome the 7A38(1)L requirement if somebody signed electronically?
I think that would satisfy the 7A requirement. I think it's important to note the laws that were on the books at the time that this statute was amended, that we required the party signature. We already allowed service by facsimile under Rule 4 and under Rule 5, Your Honor. We already had the Electronic Transactions Act that Your Honor just mentioned. So there are ways for parties to remotely sign documents, and that may be one reason why the legislature saw it fit to amend the statute of frauds here and require the party's signature. There's a bunch of case law interpreting what satisfies the electronic signature requirement, and I don't see any reason why none of that could have taken place here. Regardless, if this court is to interpret the statute of frauds to allow an agent or some other person to sign on behalf of the party, that doesn't resolve the question in this case, because we have to decide whether or not Ms. Thompson, who was Ms. Boswell's attorney during this mediation, actually had that authority or had apparent authority.
Mr. Gibson, is there anything other than Mr. Boswell's affidavit that would say that she did not have that authority?
I think that's where the summary judgment standard is important. Number one, because I think Mr. Boswell's affidavit standing on its own does create a genuine issue of material fact. But number two, I think if we look at the course of the mediation, especially if we look at it in the light most favorable to Mr. Boswell still attended the mediation. He certainly wasn't physically present, but the evidence is that he attended by telephone. That indicates that there was some reason why he was still being contacted by telephone, and there was some final execution or authorization he had to make before his attorney could execute this mediated settlement agreement. And I think there's a genuine issue of material fact as to whether or not he ever gave that authorization. But if his attorney had carte blanche to sign for him or to negotiate and execute a settlement, there was no reason for him to attend the mediated settlement conference in the first place. So,
but that was not my question, sir. I was basically asking, is there anything other than Mr. Boswell's own affidavit that is quite frankly self-serving, as you would expect it to be, that indicates that she did not have the authority to be able to sign on his behalf?
There isn't, but I think, again, the standard here isn't that Mr. Boswell has to show that his attorney didn't have authority. It's that the plaintiff has to show that Mr. Boswell's attorney did have authority and that there's no genuine issue of material fact about that authority. Now, plaintiff's counsel cites...
I was just going to say, sir, I believe that our courts have generally held that you cannot file an affidavit making a question of fact or, something that would be needed to be considered specifically at summary judgment just based on your own affidavit, your own statement.
I think in this context, where the question is whether or not he gave his attorney authority, I don't see any other way that he could have presented evidence as to whether or not he actually gave that authority. The question is whether or not he took this action, which is sort of a verbal act. So there is sort of an evidentiary issue here, which is how does Mr. Boswell say I did or I didn't give my attorney authority? And at the end of the day, it's his authority to give or not to give in this case. And I think his affidavit is pertinent to that point. I think even if we don't rely on his affidavit, there are still genuine issues of material fact that Preston Cornelius's affidavit raises. If we look at that affidavit closely, he talks about two different documents. He talks about a memorandum of understanding that the parties agreed to, and he also talks about a memorandum of judgment that Mr. Boswell authorized. Memorandum of judgment is a very different thing to a memorandum of understanding, and there's no record evidence that there was a memorandum of judgment that either of the parties signed in this case. So I think even if you just rely on Preston Cornelius's affidavit, there still are genuine issues of material fact. But more importantly, Your Honor, an attorney doesn't just have inherent authority to execute documents or create a settlement agreement on behalf of their client. Our courts have expressly held that. The case that perhaps explains the rule in this case the most clearly is the case Royal v. Hartle. That discusses both the presumption that plaintiff raises and the general rule that an attorney doesn't have inherent authority. The court there says that an attorney generally doesn't have the inherent authority to make an offer in compromise of a disputed claim. But the court goes on to say there are circumstances where there is a presumption that the attorney had authority. But those circumstances are limited to a consent judgment. And there's two reasons why those circumstances would logically be limited to a consent judgment. Number one, when an attorney enters a consent judgment, they're not just making a representation to a mediator or opposing counsel through an ambiguous memorandum. They're making a representation to the court. And when an attorney makes representations to the court, there are Rule 11 implications and also rule of professional conduct implications for that representation. So we assume that when attorneys make representations to the court, those representations are true. Secondly, in the context of a consent judgment that's already being entered, the standard is the opposite of this case. Once a consent judgment has been entered, once an order becomes final, there's a presumption that that order was properly entered and had a sufficient, competent factual basis. It's the opposite when you're trying to enforce a memorandum of settlement. You have to prove that there's no genuine issue of material fact and that the memorandum of settlement is enforceable. And that's just not what happened in this case. The other cases the plaintiff cites enforcing oral settlement agreements or settlement agreements where one party disputes the settlement agreement, in those cases, the parties expressly conceded that they gave their attorney authority to settle the case. In Harris v. Ray Johnson, the court says they expressly concede that there was authority to negotiate and execute a settlement, but there was a dispute to the extent of that authority. In Harmon v. Francis, the plaintiff's attorneys both conceded to the court that the attorney had the authority to make a settlement agreement for that case. That's just not the case here. Mr. Boswell's affidavit is, I didn't see this memorandum of settlement. The first time I saw it was June 4th, which was more than almost a month after the mediation, and that was in the context of receiving a demand letter from opposing counsel that said, you can either sign this other settlement agreement that we've drafted, or we can try to enforce this memorandum of settlement as a mediated settlement agreement.
Mr. Gibson, this was not a difficult settlement statement, was it, sir? I mean, it basically had two material provisions. Is that correct?
I think there were three material provisions. There was an amount that was to be paid, there was some property that was to be returned, and I think that the third material agreement here is the agreement to agree to a future settlement agreement with more details. All of the parties here agree that the parties expressly contemplated more details to fill in. Now, my client never had an opportunity to negotiate those more details because the first time he encountered a settlement agreement, it was in the context of sign this agreement or we'll move to enforce a memorandum of settlement against you. So
don't we normally talk about material provisions? And it seems like the amount of money and the return of the items is those are the two material provisions.
If it weren't for the North Carolina Supreme Court's decision in Chappell v. Roth, I would likely agree with Your Honor. In Chappell v. Roth, the court considered what is to me a very similar settlement agreement. There, the parties agreed to $20,000 payment and a voluntary dismissal of claims, plus a mutually agreeable release. And the court said that that was an unenforceable agreement to agree because the mutually agreeable release was a vague term and there was no ability to fill in the material terms of the mutually agreeable release. And more importantly, the court in Chappell said, we're not going to partially enforce this settlement agreement. So we won't enforce the terms that are clear because the mutually agreeable release was part of the consideration for the settlement agreement. I think the same is true here, that the settlement agreement that the parties expressly contemplated with more details, such as a release or non-disparagement or confidentiality or any of the other agreement terms that parties often include in settlement agreements, is even more vague than a mutually agreeable release. It's material because the parties chose to include it in the contract. It's a very short memorandum, and the fact that the parties include the phrase settlement agreement, by my count 4 times in the memorandum, indicates that this settlement agreement is important to them, and the terms of that settlement agreement are material. In fact, in the case of the payment and the return.
And also Boyce is somewhat similar to Chapel that you're referencing as well, where there are detailed provisions as part of that preliminary agreement, but then there's a caveat at the end that says something to the effect of, a more detailed agreement is forthcoming at a later date. So that's analogous to the argument as well, right?
I completely agree with that point, Your Honor. I think that the language in Boyce is remarkably similar to the language in this case.
Let me ask you a question here. Would you, in regards to sort of what you term sort of the or what Boyce terms as self-defeating terms within the preliminary agreement that sort of prevent us from, and Boyce prevented its enforcement. If instead of, here it says this is only a memorandum and a settlement agreement with more details will be drafted. If instead it said something to the effect of a more formal settlement will be drafted, would you be making the same arguments, or is there a distinction between promising something more formal in the future versus promising something more detailed?
I think there is a distinction between promising something more formal and promising something more detailed. Details implies more terms. It implies something to fill in. Those details aren't just, we'll sign the same document. Those details are things like releases and non-disparagements and confidentiality clauses. That's the same thing that Boyce addressed. So yes, I think if the parties said there'll be a more formal settlement agreement, then I don't think it would be as self-defeating. But I think the memorandum itself indicates sort of its tentative nature. You read it and you see this is only a memorandum, more settlement details will be forthcoming. You can see that the attorneys are sort of signing this thinking, well, this is maybe not the final agreement. We maybe don't have full authority to settle this case on these terms. Maybe our clients are thinking of other terms that they want to add to this settlement, which is the same case that we had in Chapel and the same case that we had in Boyce.
However, the language of this, the agreement or the document that was signed here suggests, unlike in Boyce and some of these other cases that talk about there not being a mode to determine what those terms are going to be, why shouldn't we be looking at the terms of the agreement here, that execution of the settlement agreement, which will be drafted by attorneys Andrew Cornelius and Marissa Thompson, as the mode? That once these attorneys come to an agreement on what it's going to say, the parties don't have any more recourse. They've decided here that the mode to determine those terms was going to be set out by the attorney. Why wouldn't that satisfy the agreement setting out the mode for determining those terms that aren't included?
I think that goes to the nature of the attorney-client relationship, Your Honor, which is when an attorney is negotiating a settlement, an attorney acts in, to a certain extent, a representative capacity for their client. So if we say my attorney and your attorney are going to sort out some terms, I think it's at least implied in that term, certainly if we're taking the facts in the light most favorable to the non-movement, that the attorney is going to act as the client directs them to act. The general concept with an attorney-client relationship is that the attorney may have some say over means, but ultimately it's up to the client to decide the ends, whether or not they want to go to a trial, whether or not they want to settle a claim, the amount of the settlement that they want to take, the terms of that settlement agreement. So I don't think that that is a clear delegation of that authority. And I think even if it was, there's still at least an implicit assumption that Mr. Boswell's attorney and Mr. Mason's attorney are going to continue to act on their behalf and as they direct.
Let me ask one question, because as you know, we don't have a transcript. We don't have copies in the record, from what I see, of this proposed settlement agreement that was going back and forth. So how, based on the record, do we know that the additional terms were actually material? Aren't we just speculating as to what's not in the record?
Well, first, let me say there, if we are speculating on whether or not they're material, I think that creates a genuine issue of material fact for Rule 56 standards. If we don't know what those terms were, then when we're at a Rule 56 hearing, we assume that those terms are material because we take the facts and all inferences in the light most favorable to the non-movement.
What if there was, as part of the record, the promised settlement agreement, and it was just these two terms, which indicates that there really weren't any more material details? Would you still be arguing that what was signed here, the memo, was not enforceable?
I think that would be a different factual scenario, and I think that would indicate that the parties didn't intend to include any other material terms. But I think the fact that there is at least some reference in the record to another more detailed settlement agreement, everyone's saying there were more details in that settlement agreement, the parties intended there to be more details, implies that those more details were material to the parties. That's why they chose to include it in the contract, and that's why they chose to continue dickering over those terms, which ultimately resulted in this memorandum of settlement, at least attempting to be enforced as a mediated settlement agreement. So
There's no indication that there were any other requests for any other terms to be provided. The only action that was filed was for money to be recovered, and then there was an answer that basically said, I'd like to have my material be my vehicle and 2 seats returned. There were no other players for any kind of relief, were there, sir?
there were both claims and counterclaims in this case, and I think it's important to note that this is arising out of a fairly small community of sort of semi-professional car racing, where your reputation is important to your business. And I think in that context, something like a confidentiality or a non-disparagement clause could be very material to the parties. I think if my client had gone after this and continued to say, well, Mason Mitchell Motorsports ripped me off, they're terrible, they defrauded me, which is what his answer says, I think that certainly would have seemed material to Mason Mitchell. But because the memorandum is an unenforceable agreement to agree, at the very least, there's a genuine issue of material fact as to whether or not Boswell's attorney had authority, and the statute of frauds bars its enforcement without Boswell's signature. This court should reverse the Superior Court's order enforcing the memorandum as a mediated settlement agreement. Thank you.
Mr. Gibson, real quick, a question for you to think about before when you get back up on rebuttal. Page 14 of your brief, and then I think it's maybe pages 6 and 7 of your reply brief, you're talking about the document that was attached to the unverified motion to enforce, and being really the memorandum we're talking about here. I would like to hear about how that argument as to the court's consideration of that document was preserved or not preserved at the trial court level.
Thank you, Counsel.
Mr. Cornelius, about that as well.
Thank you.
Thank you, Mr. Gibson. Cornelius, are you ready to proceed on behalf of the appellee?
Yes, Your Honor.
Please do so.
May it please the court, Chief Judge, judges, my name is Andrew Cornelius, and along with my co-counsel Garrison White, who's here with me today, we represent the appellees, Mason Mitchell, doing business as Mason Mitchell Motorsports, and Mason Mitchell Motorsports, Inc. Before I get into addressing the issues in dispute before the court, I think it's important to take note of the undisputed evidence in the record. And there are essentially three significant points I want to make that are undisputed. First is that there was an agreement for the mediation to take place with the parties not in attendance, which is allowed by by General Statute 7A-38.1. Second, the mediation took place and it resulted in a settlement that resolved all issues in the case. Now, this is demonstrated in the affidavit of Judge Preston Cornelius, who was the mediator. And the fact that this case was resolved, that all issues were resolved, is not disputed in the record. It's not disputed by Mr. Boswell in his affidavit. The resolution of this settlement was then memorialized in a memorandum of settlement, which was signed by the mediator, signed by myself as attorney for Mason Mitchell Motorsports, and signed by Mrs. Thompson on behalf of Mr. Boswell. Again, this is all in the affidavit of Judge Cornelius. And third, the memorandum of settlement in the record contains the terms of settlement. There is no dispute by Mr. Boswell in his affidavit of what the terms of settlement are. And those terms are that the parties will mutually dismiss all claims against each other, that Mr. Boswell will pay to the plaintiff $45,000, and that the plaintiff will release certain personal property to Mr. Boswell. Those are the terms of the agreement, period. So what we have is we have a mediation that was a little bit different because the parties didn't attend, but they agreed to that. It resulted in a full resolution of all issues in the case, and it was reduced to writing and signed by the attorneys on behalf of their clients. And that's uncontroverted in the record.
Let me ask you a question real quick, Mr. Cornelius, is regarding material terms. You know, a lot of times what I saw in practice and in most boilerplates when you see a settlement agreement also includes, you know, global releases. So say the settlement agreement included a global release, but Boswell wasn't going to agree to a global release, which isn't, you know, here in this memorandum. Would the settlement agreement be able to go forward? I guess I'm trying to think is, you know, our typical boilerplate, he's talking about confidentiality agreements and things like that, but I'm thinking of something you see more universally, global releases. You know, that's not there. You know, is that not a typical material term that you see in agreements, and that would be important to determining, you know, what would typically be in a full-on settlement agreement?
Certainly, a global release is something that is often included in settlement agreements, but again, that would purely depend upon if that was agreed upon by the parties at the mediation or not. In this particular case, the terms of the settlement do not include any specific language regarding a release. To the extent that they sought release language, it's in the fact that they agreed to mutually dismiss with prejudice their claims in that lawsuit, which of course would act as a bar to anybody reasserting those claims in a different way in the future. But I think that for purposes of this court's review of this case, we can only consider the things in the record and not hypotheticals of what the parties could have been or would have been. The fact is there is no ambiguous term in this contract or material term that the parties needed to agree upon later.
So I'd like to ask, also speculating then that there aren't going to be more material terms, that this new settlement agreement is going to be silent as to anything else that might be material? Isn't it the same level of speculation there that it would be about a global release or confidentiality agreement?
Well, Your Honor, I think that the issue there is that in most mediations, when parties settle a case in a mediation, they write down the material terms of that agreement and everyone signs it. And almost always there is a subsequent agreement that is longer or more comprehensive or contains more information. There are different ways we could say that. The fact that that is the practice and the fact that the parties may decide to include more terms later on does not void or undo the underlying settlement they reached. in any contractual arrangement, if I enter into an agreement with someone else,
Can you
I can.
distinguish? Can you tell me how you distinguish this case from the Boyce case
Yeah.
that we talked about previously, which features a number of quite detailed provisions, but at the end has this is a preliminary agreement. By executing a more detailed agreement at a specific subsequent date, we're going to come back to this. And we didn't enforce the provisions that were laid out there because of that sort of hanging more details forthcoming language in Boyce. And I want to try to understand how this case, in your eyes, is different than Boyce.
Certainly, Your Honor. And a couple of things there. The first is that Boyce deals with the with a development of land transaction. It contemplates factually a lot of different things that will need to take place in this preliminary agreement, and issues that will need to be resolved by the parties so that they can then enter into a more formal agreement of exactly how the land will be sold and how it will be developed. The preliminary agreement, that's the term they use in Boyce, is similar to what I would consider a letter of intent, which is essentially the parties coming together and putting in writing something that says this is what we intend on doing. The term desire is used throughout that preliminary agreement in Boyce. The parties are expressing their desires of what they want to see in an agreement in the future. The difference here is that all the material terms of the settlement agreement are contained and stand alone. The fact that the language of this memorandum of settlement states that a more detailed settlement agreement could be entered in the future just follows along with general practice in mediated settlements. I mean, to take the argument in Boyce kind of to its extreme conclusion would essentially mean that at mediations, parties could never enter into a memorandum of settlement in anticipation of a further future, more formal agreement. And it's impractical that parties would enter into, what might be the full agreement, particularly in significant cases that have a lot of issues in them.
Well, I think that this case would certainly be different if the language that was hanging at the end was, we're going to have a more formal agreement that's going to be forthcoming. We could have a meeting of the minds that happens on a napkin. That would be a feature enforceable terms, but we might put at the bottom of that napkin, we're going to put something more formal together because we don't want our agreement to ultimately be memorialized on something that we worked out over coffee or over a beer, right? So it does seem to me, in the brief, you talk in the language of formality in your brief as well, but is there a difference that's an important legal difference between saying there's a more formal agreement that's forthcoming as opposed to a more detailed agreement that's forthcoming?
Well, I think at this point we're dealing with semantics and just word choice and usage and how people want to interpret or try to interpret that. I think that the things that would concern me is if the memorandum stated that there were additional terms to be agreed upon by the parties, or some language to that effect, and it doesn't state that. It just says that there will be more details, and details don't. I would argue that details is closer akin to a formal settlement agreement than additional or new terms of the agreement, because I think of terms as being things that are more material to the agreement. Now, this is an argument over, like I said, semantics and how someone wants to interpret a specific word or word usage, but there's nothing in that memorandum that would indicate that the parties want to add terms or to change the substance of the agreement. It just leaves open the ability for the parties to enter into a more detailed or a more formal agreement than what's contained in that memorandum. But the memorandum itself stands on its own as an agreement settling all issues. And that's further enforced by the affidavit of Judge Cornelius, where he states that the agreement, that the mediation resulted in a settlement of all issues, which was reduced to writing.
Mr. Cornelius, let me ask you real quick, and sorry, this is something that's just coming to me as we're sitting here looking at the memorandum for the 50th or 60th time. In your choice of words now when we're arguing, you're saying, it's important to look at the difference of the term. The opening here in the memorandum, and I'm looking at record page 88, says these are the following terms and chooses the word terms there. However, the language that we have concern about making it more like Brooke uses, or more like Boyce, sorry, Chris, uses the word details instead of terms. What significance should there be to that? Is that a recognition that there won't be more terms added, that it'll just be details regarding terms, since terms are what's listed and says these are the two terms? Is that a fair interpretation, or is that the point of your argument, or am I just making something up for you on the fly and something I shouldn't be doing?
No, correct, Your Honor, and that's exactly what I was stating to Judge Brooke, is that the material terms, which is why that word is used, terms, because those are the material terms of the agreement. The additional details that could be contained in a settlement agreement would just be any further details the parties want regarding these terms. For example, there could be details in a more formal settlement agreement about how the parties were to arrange for the retrieval of the personal property. Those are details that could be included in a more formal agreement. Those certainly would not alter the terms, and they're not material terms to the agreement. The material terms are what are contained in the memorandum.
How is the fact that we're at what is an MSJ phase of this proceeding, and that's how we assess this, impact what you're saying? I understand the argument that you're making, which is that it's possible that all we're doing is trying to sort of flesh out how we're going to effectuate these terms, right? That's definitely one version of what those details could imply, or could be talking about. But it could be something else that we simply are not well positioned.
Right.
And should we be, as Judge Murphy asked earlier, are you asking us to speculate here at a stage where we shouldn't speculate?
No, I'm not asking you to speculate at all. I'm asking you to take this agreement at face value for exactly what it says and provide no speculation whatsoever. The difference here is that if there was an opposing affidavit from someone that stated that the terms contained in this memorandum of settlement were not the actual terms of the agreement, that there were different terms, then that could create a factual issue under the summary judgment standard. But there is no such contradictory evidence in this case. Rather, the only evidence regarding the quote settlement is Mr. Boswell stating that he did not give authorization for his attorney to sign this document. Nowhere does Mr. Boswell dispute that these are the terms of the settlement that was reached at mediation.
Let me ask, I think this might flow somewhat nicely into the issue appellant raises at page 14 of its brief regarding the authenticity of the document that was just attached to unverified motion. What is the basis that should be part of our de novo consideration, or should have appropriately been part of the consideration of the trial court, just because it was attached to an unverified motion? It's not incorporated by reference from what I see in either of the affidavits.
So a couple of points to respond to that. First is that this motion is made under Rule 11, which requires certification and signature by the attorney that it's factually true and accurate and grounded in legal principles that they're acknowledged by the court. Second, the affidavit of Judge Cornelius, let me pull that up for the exact language. States that the mediation resulted in a settlement that resolved all issues memorialized by a memorandum of settlement signed by myself, Andrew Cornelius, on behalf of his clients, and Marissa Thompson on behalf of her client. And his affidavit says that the mediation occurred on April 29th, which is the date of the memorandum. So
But that we're making assumptions that the memorandum is what it purports to be. What takes me on that step from the memorandum that's mentioned here, or memorandum of settlement, as the mediator calls it, to this paper writing that shows the word memorandum on it? What authenticates that for Rule 56 purposes?
right, and so the final point I would make is I would direct your attention to the case of Fuby v. Hammock Enterprises, which is a 1999 Court of Appeals decision, which is cited in our brief. And in that case, that was a case that regarded the enforcement of a mediated settlement agreement. In that particular case, the parties reached an agreement at the mediation. The mediator subsequently drafted a mediated settlement agreement. At the request of a party, he amended it and drafted a separate agreement, which then one of the parties refused to sign, and so a motion to enforce that memorandum was filed. In the analysis and ultimately in the ruling in that decision, Judge Green for the Court of Appeals ultimately held, because one of the issues raised at that time, that was under a prior version of 7A-38.1, which prohibited the admissibility of any statements made or negotiations made during mediation before the statute was subsequently amended to create certain exceptions now. The court held that they did not read the statute as prohibiting the admission of testimony or other evidence of the outcome of the mediation settlement conference before a judge making the determination of whether the settlement was reached. And there's a footnote in that case, and the footnote states that the report of mediator, which noted that plaintiffs and defendants had reached, quote, agreement on all issues, end quote, and the two versions of the mediated settlement agreement prepared by the mediator constitute admissible evidence in this context. And I would contend that what occurred here is similar to that, in that while we don't have in the record the report of mediator, I never received a copy of it. I presume it's in the file in Iredell County, but I've never received it, and it wasn't part of this record. We do have the affidavit of the mediator here stating that there was a written document and that there was an agreement of all issues. So I think the same
affidavit doesn't point us to this document. I mean, well, I think it's probably a fair assumption, and maybe it probably was, but for moving forward without a jury trial, you know, it's a pretty high standard. And if something's not properly before the trial court, then I guess I have severe concerns with whether the trial court even, well, I think it's clear the trial court did consider it since they attached it to its order. But if there wasn't any argument made as to why it should be viewed as being the document it purports to be, you know, how do we get past that hurdle? When, you know, the case you're talking about, in that situation, you know, he's also saying there was this. I'm not looking at the affidavit specifically in that case, but here, you know, the mediator doesn't point to a document. He could have easily incorporated by reference or attached a copy of it. And your client could have produced that, and your client has the burden to move forward on summary judgment.
You know, and I understand the point you're making, Your Honor. And again, I think that there is some amount of inference that the document referred to in the affidavit of Judge Cornelius is in fact the memorandum of settlement because of the terms that it contains, because it's signed by all the people he identifies, because of the date that it's done. And again, Your Honor, there's no contradictory evidence from Mr. Boswell that these aren't the terms of the settlement agreement. There's nothing that he has provided to rebut that this agreement is the terms of the agreement that were reached at mediation.
Talking about this document, and maybe we're talking about other documents or we're not, I'm looking at record page 94. The second paragraph, the first sentence of the trial court order, the first sentence of the second paragraph of the trial court's order. After reviewing the court file, which obviously appropriate the affidavit, and submission of the party, what in the record shows any submissions of the parties that were being considered? Is there a lack of the record here? Is this boilerplate the judge included when he didn't mean to? Was it memorandums or bench briefs that we're not aware of? What are we talking about here? Or are we talking about the document?
So the document was attached to the motion to enforce memorandum of settlement. So it was in the court file. It may have also been handed up to the judge at the trial level. I believe that there was a memorandum handed up to the judge or presented to the judge as well, which would be a submission. I don't think that that's part of the record before the court here. I don't think that was included by the appellant.
Is there an objection to handing that up at all at the trial level if it was handed up?
Not to my recollection. It was, I believe the Mr. Boswell, his attorney, provided the memorandum. But I'm not aware of any other submissions beyond the affidavits. And there may have been, I can't recall, but there may have been some case law that was handed up as well, Your Honor, which would be a submission to the court, some statutes.
And I guess one of the concerns, there's not a transcript, obviously, which would be great, but there's not, a Rule 9 summary either for us to know what happened at the trial court. We get into this a little bit with the equitable estoppel argument you've raised in your appellee brief. But we don't have any record that was made or wasn't made below, and there's no narrative offered by the parties. There's nothing suggesting that was made or that your fraud argument was made below. So I guess my question is, what do you contend in the appellant's case was not preserved, if anything? What do you say about issues raised in your appellee brief not being preserved properly? And then who has the burden to make sure we have a preserved record of what arguments were made below to avoid horse swapping?
So to answer those questions in reverse, I think that the appellant, to the extent that the appellant is seeking the court to review a decision of the trial court, they have the burden and the obligation to make sure that a sufficient record is before this court to actually make that appropriate review. So that would be the burden on the appellant. I think most of the arguments that have been made to this court in some form or fashion were made to the trial court with regard to preservation of arguments in this case.
And what about the equitable estoppel issue that you didn't get a chance to respond to that in writing because the fact that the appellant says that wasn't preserved comes up in the reply brief. So what is your position on whether that was preserved?
So there was an argument made to the trial court that generally talked about estoppel in terms of the fairness and interpretation of the statute. That the argument essentially was made that that Mr. Boswell had agreed to a settlement that and that essentially he had changed his mind and should be stopped from doing so. And that argument was not developed, and there was certainly not a submission of a written argument to the court at the trial level of that argument.
So it's a little bit different than if I'm understanding your estoppel argument here about arguing that the signature mattered when you guys in good faith set up that he was going to be absent, your client was going to be absent. So there seem like two different estoppel arguments from what you're telling me. Are you saying they're similar enough to say that was preserved?
Correct, Your Honor. That the fact that he agreed to do the mediation from remotely without his physical presence, our argument is that in doing that, he granted authority to his attorney to execute such documents as might be necessary to formalize the settlement at the mediation, and that by him subsequently arguing different from that is what reaches the what ends up being the basis for the estoppel argument that we argued in the brief.
There are 2 points in your brief, one at between 26 and 27, and then also at page 14, where you talk about good faith versus bad faith. Are you aware of any cases or any statutes that require a litigant to participate in the mediation in good faith? My understanding has always been the only legal duty is to participate and to come. If you get to an impasse immediately, you don't have any desire to do anything, then that has no impact. The good faith, there is no good faith obligation at all when it comes to mediation.
Correct. In terms of what happens, that's correct, Your Honor. I don't disagree with that. You have to comply with the rules in terms of your attendance. You have to be there unless you're excused, which is what occurred here. By the parties agreed to that.
So for you, it boils down then to the estoppel comes in because he acted in bad faith or violates y'all's good faith negotiations to allow everybody to attend remotely.
Right. In essence, Your Honor, the argument is that there was no point in us having the mediation whatsoever based on the argument he's raised, because essentially what he's stating is that by us having the mediation remotely, which obviously we're required to have the mediation for the convenience of the parties, we allowed it to occur remotely. It was agreed by everyone, but essentially the argument that he's making is that the mediation, by being done remotely, there was essentially no way that it could be binding upon him.
But if we put on the idea that the Electronic Signature Act would be satisfied, doesn't that negate that portion of it? That obviously he could have signed something, emailed it back, faxed it back, or whatever, if it had been presented to him and parties waited on the signature.
Certainly, Your Honor, but I mean, there's always a better way to do something, and that would have been a better way to do something. I think that if that was what the parties desired, then when we agreed to mediate this remotely, that's something that should have been raised and said. It was an understanding that we were going to mediate this remotely, and that if we reached an agreement, we would be able to comply with the terms of the statute to reduce it to writing and sign it, and it would be enforceable and binding on the parties at that time.
Let me present you with a hypothetical real quick. Let's say this this mediation occurred in person. Everybody was there, sitting around the table, like they normally do. Hey, everybody's happy now. End of a long day. We've got an agreement. Gets written down, just exactly like we have here. And the mediator signs, the attorneys have both signed, the defendant walks up to it, gets ready to put his pen to paper, and gets cold feet. The attorney has already signed, so where does that come in your arguments about whether that attorney had authority to sign when the person was present and available to sign? Would this be able to be enforced even though the defendant, before putting his pen to paper in the room, got cold feet, but his attorney had already signed?
I think that's a completely different scenario than what we have here, and I do not think that would be enforceable under the statute. There's a distinction made in the statute, subsection 4A2, under physical attendance required, where it specifically states that the party or person is required to attend the settlement conference shall physically attend until an agreement is reduced to writing and signed as provided in subsection C. Subsection C refers to finalizing agreement. But then that same statute goes on to state that any party or person may have the attendance requirement excused or modified under certain conditions. That second part then does not contain that same language referring to subsection C about how the agreement is finalized. And I would contend that the statute allows these agreements to be finalized without the party's signature together. For these and the other reasons I've stated, I would ask that the court affirm the decision of the trial court. Thank you.
One more question, Chief, if I may. I just want to be perfectly clear. Are you stipulating that the statute of frauds argument was raised below. Are you conceding that?
Yes, that issue was raised below by Mr. Gibson. Yes, Your Honor.
Thank you very much.
Thank you, sir.
Thank you.
Mr. Gibson, do you have a rebuttal?
I do, Your Honor.
Please proceed.
Thank you, Your Honor. I'd first like to address the issue preservation issue that Judge Murphy has asked. I think the parties have stipulated that the issues that appellant raised at this court were also raised at the Superior Court. I did submit a brief to the trial court. The reason why that's not included in the record was it was not filed with the trial court, and I believe it's largely duplicative of my briefing to this court. There's also authority, which is not in our briefing. I'd be happy to submit a memorandum of additional authority on the issue of raising the preservation issue and whose burden it is to raise a preservation issue. If Your Honor would like, I'd be happy to submit memorandums of additional authority on that issue, obviously with the understanding that opposing party would have the same opportunity. But in closing, I'd like to point out that the factual issues here are still present in the record. And one of those factual issues is the issue with Preston Cornelius's affidavit. He talks about two different documents. He talks about a memorandum of understanding. He talks about a memorandum of judgment. He doesn't attach either one of those documents to his memorandum, or to his affidavit, rather. The only document attaching the memorandum is the unverified motion of the plaintiff seeking to enforce the memorandum. The pleadings of parties aren't evidence. There needs to be some affidavit or some witness at summary judgment that has personal knowledge of that document saying, this is actually the document we signed, this is actually what we agreed to. Plaintiff's argument rests on a series of inferences and assumptions, as plaintiff expressly concedes, that the term...
Mr. Gibson, can I get you to respond? And I know you have only a few moments here to get this out to you quickly. I understood Mr. Cornelius to distinguish voice on two different grounds. One, and I think this is fair, one is there's desire language in there that seems less certain than the language that's involved here in the material terms. And also, to boil that down, the terms involved in voice were a lot more complicated and needed to be fleshed out in a way that could have material impact. Whereas here, we're dealing with material issues that are it's a much more limited universe of material. That's the two distinct distinctions I understood him to make between this circumstance and voice. Can you respond really briefly to those distinctions?
Certainly, Your Honor. On the first issue, I don't think you can escape the issue with an agreement to agree by making that agreement more simple and just contemplating other terms in the future. So this agreement says these are the terms of the voluntary dismissal, but there'll also be a future settlement agreement with more details. That's the same issue that Boyce faced, which is that litigation is just as complicated as purchasing real estate. There's just as many material terms to a mutually agreeable settlement release, including mutually agreeable releases, which is what the court considered in Chappell. And on the second point, which is the factual distinction here, the memorandum expressly says this is only a memorandum and a future settlement agreement with more details will be drafted. That is tentative language that's not typical to include in mediated settlement agreements. There's no reason why the parties had to include that language, but they chose to include that language. They could have simply ended their memorandum, not included that sentence, and plaintiff's argument would still be the same. But they chose to include that language because this was a tentative agreement. And for that reason, the authority issues and the statute of frauds, this court should reverse the Superior Court's order enforcing the memorandum as a mediated settlement agreement. Thank you.
Let me just get some final clarification on what Mr. Cornelius was saying about what happened before the trial court. He indicates that I don't want to say his memory, but just a loose recollection is that you or representing your client were the one that submitted the physical memorandum to the trial court. Is that your recollection?
I did not submit the memorandum, and I don't think that that's what Mr. Cornelius was saying. I think the memorandum was attached to plaintiff's motion, and that is how it came to be in the trial court's hands. I submitted briefing to the court, and Mr. Cornelius submitted some statutes and other authorities to the trial court. To my knowledge, that's all that was submitted in terms of paper writings or anything of that sort.
Did you lodge any objection to the court's consideration of that document before the trial court?
Of the memorandum?
Yes, regarding
I did.
the authenticity issue.
I made the same arguments to the trial court that I've made to this court, and I think Mr. Cornelius has agreed to that, and that's one reason why it's not contained in his briefing that these issues weren't preserved, because these are the same arguments we had below.
Thank you, counsel.
Thank you.
Thank you. Mr. Horn, would you please adjourn court?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you all.
Thank you all.
Thank you, Your Honors.
Thank you. Have a good day.
Have a good afternoon, y'all.